The defendant next argues that his 20-year-old sentence is excessive. When he pleaded guilty, he agreed that his sentencing range would be between 5 and 20 years without benefit of probation, parole, or suspension of sentence. After reviewing a pre-sentencing report, the judge imposed a 20-year term upon defendant. Article 1, Section 20 of the Louisiana Constitution of 1974 provides that no law shall subject any person to cruel, excessive, or unusual punishment. A sentence within the statutory limit is constitutionally excessive if it is grossly out of proportion to the severity of the crime, or is nothing more than the purposeless imposition of pain and suffering. Generally, a reviewing court must determine whether the trial judge adequately complied with the sentencing guidelines and whether the sentence is warranted in light of the particular circumstances of the case. If adequate compliance is found, the reviewing court must determine whether the sentence imposed is too severe in light of the particular defendant and the circumstances of his case, keeping in mind that maximum sentences should be reserved for the most egregious violators of the offense so charged. State versus Sweet. The Louisiana Supreme Court held on appellate review of sentence, the only relevant question is whether the trial court abused its broad sentencing discretion, not whether another sentence might have been more appropriate. For legal sentences imposed within the range provided by the legislature, a trial court abuses its discretion only when it contravenes the prohibition of excessive punishment, i.e., when it imposes punishment disproportionate to the offense. In cases in which the trial court has left a less than fully articulated record indicating that it has considered not only aggravating circumstances but also factors militating for a less severe sentence, a remand for resentencing is appropriate only when there appears to be a substantial possibility that the defendant's complaints of an excessive sentence have merit. The defendant complains that the trial court did not consider any mitigating factors in sentencing him. He points out that he is only 20 years old, that his grandmother testified at sentencing that his childhood had been difficult because of his mother's mental problems, and that he confessed to being addicted to heroin. At sentencing, the trial court reviewed the facts of the offense and noted that the robbery was premeditated and that the defendant had a criminal history. According to the pre-sentencing report, the defendant, a first offender as an adult, has an extensive juvenile record consisting of 24 arrests and 8 adjudications as a delinquent between 1990 and 1996. Much of the adolescence was spent in correctional centers. As an adult, he had 10 arrests between 1997 and 1999, including another armed robbery charge which was refused by the district attorney's office. The defendant argues that the trial court should have considered the fact that he simply drove the getaway car and did not enter the restaurant. However, we note that Richard Spott directly aided in the commission of the crime. He was still at the wheel of the getaway car when the police apprehended the 3 men involved in the offense. Obviously, the trial court found that Spott has shown a continual pattern of criminal conduct and a habitual disrespect for the law, meriting 20 years imprisonment. The next inquiry is whether the sentence is excessive in light of sentences imposed by other courts in similar circumstances. In State versus Davis, 596, Southern Reports, 2nd, 358, Louisiana Appellate Court, 4, Circuit, 1992, This court affirmed 3 consecutive 20-year sentences for armed robberies imposed on a youthful offender with 6 arrests for nonviolent crimes as a juvenile and 1 prior felony conviction as an adult for possession of stolen property.